Hello, my name is Sujit Konan. Welcome to this module on waste management. In this module, we will be discussing existing legal framework in India relating to waste management. So the idea is to discuss or to understand briefly the nature, the scope and the source of the legal framework relating to waste management in India. So we will be discussing, to put in a different way, we will not be discussing all legal instruments relating to waste management in India. Instead, that's not, within this short available time, we will be discussing some of the key instruments and their approaches, and then the students are advised to look at other other available legal instruments relating to waste management both at the central level as well as at the state level. So we will be also mentioning or discussing briefly some of the key cases relating to waste management in India. Before we discuss the substantive aspects of waste management laws in India, let's try to understand what is the context in which we discuss waste management. And as some of the statistics shows, safe management and scientific disposal of waste is a critical issue in India. Some of these including the government statistics, it shows that approximately 90% of the municipal solid waste is being disposed unscientifically, or or many of these municipal solid waste are being disposed without treatment at all. And there is another major context is, across India in many places various public protests are ongoing against these landfills, and this brings into limelight some of the key issues relating to environmental justice and equity as far as waste management is concerned. For example, the key question is, where are we dumping waste, how are we disposing it, in whose vicinity we are conducting waste disposal and management, or to put in a different way, where these waste are coming and where they are being dumped, or whether for disposal or for just storage. And the major reasons why we are concerned with waste management is its obvious implications on public health and environment. So these are the major rationale behind waste management law in India, that is to minimize the implications or adverse implications of wastes on public health and environment. So again, what is meant by the term waste management? When we say waste management, what are the activities and stages involved in this process? So as per the legal definition available, it involves various stages such as collection, transportation, processing, recycling or scientific disposal, and it also involves monitoring of all these processes. And when we say waste management or the term waste, it generally includes waste materials produced by human activity. That means in these cases generally the natural waste, wastes produced by the natural process are not included or not within the mandate of this waste management laws. And the major purpose of this waste management legal framework relating to waste management is, as I already mentioned, to reduce the impacts on health and environment. And another key purpose of waste management process is to recover resources through recycling. That means the idea of waste being converted into wealth. That means there could be a number of materials that can be reused in the waste. So one of the major purposes of this waste management process is to identify those materials that could be recycled and reused. So that means to minimize the actual disposal. Now let's try to take a mapping of the legal framework relating to waste management in India. And as we have already discussed, our purpose is not going to make an illustration or to examine all laws relating to all legal instruments relating to waste management. Instead, we will be looking at some of the key instruments at the central level, and briefly the legal framework at the state level, and then briefly we will be looking at case laws relating to waste management in India. So as far as the key legal framework, key legal instrument is concerned, it is Environment Protection Act 1986, probably the most important legal instrument in the context of waste management in India. This is a legislation adopted at the central level. And as we can see from the Environment Protection Act 1986, there is perhaps, we will not find a provision on waste management per se. This is an umbrella legislation that focuses broadly on, generally on environment protection measures in India. However, this legislation is extremely important in the context of waste management because a number of rules have been adopted under this 1986 Act that focuses on different kind of waste. When I say different kind of waste, this has been an approach, a key approach followed under the Environment Protection Act 1986, because we have different rules addressing different wastes. For example, we have a separate rule on legal instrument on municipal solid waste. We have a separate legal instrument on hazardous waste, and so is the case with electronic waste. So in this module, we will be dealing with we will be briefly discussing municipal solid waste rule, rules on hazardous waste, and rules on electronic waste. However, students are advised to look at other legal instruments relating to wastes, for example biomedical waste or plastics to get a comprehensive idea of the legal framework relating to waste management in India. In addition to Environment Protection Act 1986, at the state level we have two sets of laws. For example, in the rural context we have Panchayati Raj laws, and urban context we have law governing urban local bodies. The importance of these laws in the context of waste management is these laws essentially contain provisions relating to waste management, and these laws inevitably makes it a duty of the local bodies, whether it is both in the rural as well as in the urban context, to address the issues of waste management. And in addition to these statutes, there are a set of case laws dealing with waste management in India, and we will be covering some of the important case laws in this context. And in addition to these statutes and case laws, we have a number of policies, programs, and schemes both at the central level as well as at the state level dealing with waste management. For example, Nirmal Bharat Abhiyan, which has been recently renamed as Swachh Bharat Abhiyan. Because while these policies and programs are extremely important, we will not be discussing in detail these policies and programs. Instead, students are advised or strongly encouraged to look at all these policies and programs to get a comprehensive idea about the overall framework relating to waste management in India. As we have already mentioned, our focus as far as the examination of the legal instrument is concerned, we will be focusing on three instruments. Instruments relating to municipal solid waste, electronic waste, and hazardous waste. First is municipal solid waste management. So when we say municipal solid waste management, what are the processes and stages involved in this process? It involves generation, storage, collection, transfer, transport, processing, and disposal of municipal solid waste. So when we say municipal solid waste, the municipal solid waste rules have provided a definition of an illustrative definition of municipal solid waste, which includes food waste, rubbish, commercial waste, institutional waste, street sweeping waste, etc. So that means the rule or the legal instrument focuses on various stages involved in the eco-friendly disposal and management of solid waste. So municipal solid waste management and handling rules was adopted in 2000. So before we get into the substantive aspect of the rules, it is pertinent to mention the role of the role played by the Supreme Court in the adoption of the rules. There was a case before the Supreme Court called Almitra Patel case 2000, decided by the Supreme Court in 2000, and this case is extremely important in the context of municipal solid waste management and handling rules 2000, because there was a committee set up by the Supreme Court as part of this Almitra Patel case, and this committee drafted a rule on a document on municipal solid waste management that became the foundation of municipal solid waste management rules. So what we can see is that the Supreme Court played a significant role in the adoption of municipal solid waste management rules 2000. A key feature of the municipal solid waste management rule is the duty entrusted with the municipal authority. Municipal authority is the key institutional mechanism that has been entrusted with important functions relating to solid waste management, which includes infrastructure development for collection, storage, segregation, transportation, processing and disposal of municipal solid wastes. As we can see that municipal authority is duty bound to establish infrastructures for all these key processes involved in the management process, in the process of solid waste management. This also includes house to house collection of municipal solid wastes. And there is an important part of this provision is that the municipal authority is expected to arrange house to house collection on a basis of pre-informed timings and schedules. And the duty of the municipal authority also involves establishment and maintenance of hygienic and sanitary storage facilities. That means another major duty is the arrangement of storage facilities for municipal solid wastes. And the rule also provides some minute technical aspects of storage facilities. For example, it says that the storage facility should not be opened, or it also says that the storage facility should be aesthetically acceptable and user friendly. And there's another interesting aspect of the storage facility as or the rules relating to storage of municipal solid waste is that it prescribes different colors for different kind of municipal solid wastes. For example, it says green color storage facility for biodegradable wastes, white color for recyclable waste and black color for other wastes. One important aspect to be mentioned in this context is that it starts, the important provisions or the most of the provisions of municipal solid waste management rules focuses on the post generation aspects of municipal solid waste, because it starts from collection, transportation and ends in the disposal of municipal solid waste. So the key question is, what about the generation of waste? So as far as one of the important aspect of waste management is the viable approach. The preferred approach should be from cradle to grave approach. That means the policy should focus, the focus of the policy should begin from the generation of the waste. That means we have to minimize the generation of wastes, and whatever wastes are generated, then we have to have a mechanism for eco-friendly management and disposal of such wastes. But the municipal solid waste management rules seems to be inadequately focusing on the generation part of the process. Other important regulations as far as prescribed under the municipal solid waste rules is the manual handling of waste. It prohibits manual handling of municipal solid waste. However, this prohibition is not absolute. There are some exceptions, because manual handling of waste is permitted under some exceptional circumstances or some unavoidable circumstances. But the rules also prescribes that whenever the municipal handling or the manual handling of wastes is to be permitted, there should be adequate precaution or proper precaution for the safety of workers. It also provides for covering of vehicles using transportation of wastes. Another major rule provided under the municipal solid waste management rules is regarding landfills. It discusses about, or it deals with some technical aspects of landfills. For example, the distance to be maintained from the habitat clusters and forest areas or water bodies of national parks. It also talks about the technical aspects of landfill. For example, construction of non-permeable lining system at the base and walls of waste disposal area. It also addresses the post-closure part of landfill. For example, indirectly or directly, it insists that landfills can't be neglected after closure. The rules insist, or the rule prescribes that it has to be taken care of by the municipal authorities at least for 15 years after its closure. It also talks about periodic health inspections of workers at landfill site. So what we can see is that broadly it addresses municipal, or the management involves, or it addresses or tries to address the waste management issues from its collection or door-to-door collection to transportation to storage, including in the context of landfills. As far as landfill is concerned, one of the important issues that arises in this context is the environmental injustice involved in this process. For example, we also have to look at where these wastes are being dumped, particularly in the context of landfill. This is the context where a number of public protests needs to be public protest against landfill that needs to be looked. For example, in many cases these municipal solid wastes are being dumped in remote areas where poor and vulnerable people lives, or particularly to put in a different way, particularly in the urban context, wastes are being collected from the urban areas and being dumped at the peri-urban or rural areas where poor and vulnerable people are living. So this is a clear case of environmental injustice involved in the municipal solid waste management process. Now, another major part of this another key dimension of this role is the monitoring part. As far as monitoring is concerned, the duty is entrusted with the State Pollution Control Board, and this is Pollution Control Board is entrusted with the duty to ensure compliance with the rules, and the monitoring also involves the waste processing and monitoring of waste processing and disposal facilities. So let's move on to the next major legal instrument, that is electronic waste management. So before we get into it, what is the major context in which we discuss electronic waste? Electronic waste is the electrical and electronic equipment rejected after their manufacturing or repairing process. So broadly speaking, it talks about end-of-life electronic equipments. So what to do with these end-of-life electronic equipments? Why we are concerned with such electronic waste? Because over the last few decades in India especially, we have seen increased use of electronic equipment. So why this increased use of electronic equipment is an issue? Because we are slowly moving towards or into the habit of changing our electronic equipment quite often, because the technology is being upgraded almost on a routine basis. So everyone has a tendency to upgrade their electronic equipment that leads to discarding of the previous equipment. So this electronic waste is a serious issue that India is facing currently. So one of the major reasons for this electronic waste issue is our focus is only on use of electronic equipments, and we tend to discard what happens to all those electronic waste or discarded electronic equipments or the end of life electronic equipments. The process of management of electronic waste involves collection, scientific dispose, recycling and reuse of electronic wastes. So an interesting part to be noticed in this process is electronic waste is not completely a waste. There could be many substances that can be recycled and reused. So in this case, recycling and reuse are major parts of electronic waste management process. And electronic waste management and handling rules was adopted in 2011. Again, this instrument was also adopted under the Environment Protection Act 1986. The purpose of this legal instrument was to ensure environmentally sound management of electronic waste, which essentially includes recycling and reuse. When we say that the current scenario in the context of electronic waste management is largely this is being managed by the unorganized sector. That means we are in need of a proper organized sector for e-waste management. So what are the key features of the e-waste rules 2011? So a major feature of the e-waste rules 2011 is this idea called extended producer's responsibility. So this means the duty is upon the producers of the electronic equipment to design and implement a proper system for collection as well as of environmentally sound management of electronic wastes. So that means it is for the producers to set up the proper establishment for proper management of e-wastes. And while it is so, it provides an exception to bulk consumers, because it is the duty of the bulk consumers to channelize all their e-waste generated in their establishments and to let it reach to the proper mechanisms established by the producers. And like almost all other legal instruments in the context of waste management, the monitoring duty is upon the Pollution Control Board. Some of the important aspects of this monitoring is that all e-waste management establishments require a no objection certificate from the State Pollution Control Board. And when we say no objection certificate, this also plays a critical role in the context of interstate movement of electronic wastes, because in this case a permission from the State Pollution Control Board of all transit states are also mandatory. And another monitoring part is that producers are required to maintain a record of e-waste, and then it is the duty of the State Pollution Control Board to scrutinize the record. To move on, the third important instrument is the rule in the instrument on hazardous waste management. So the context in which we discuss about hazardous waste management is the rapid industrialization, increased use of chemicals and rise of chemical industries. So this has led to a huge generation of hazardous wastes, and then that brings us the context for an eco-friendly management and disposal of hazardous wastes. The legal responses in this context has been Hazardous Wastes Management and Handling Rules 1989, and this was later on modified in 2008. Now that we have a new document called Hazardous Waste Management, Handling and Transboundary Movement Rules 2000. A significant difference of this 2008 instrument when compared to 1989 instrument is that this is a comprehensive instrument which covers both the domestic aspects of hazardous waste management as well as the transboundary movement of hazardous waste management. I mean, the rationale behind this rule is, again, I mean, to protect health and environment from this menace of hazardous waste. So one important aspect of hazardous waste management rules 2008 is that it does not deal with wastewater, municipal solid wastes, radioactive wastes and bio-wastes. I mean, the reason is quite clear, because as far as these wastes are concerned, there are separate instruments in existence. And it talks about, I mean, hazardous waste management rules entrust the responsibility for eco-friendly management of hazardous waste with occupiers. That means, I mean, it casts duty upon the producers of hazardous wastes to manage, to establish a mechanism, whether through themselves or to entrust it to another individual or company having sufficient mechanism for hazardous waste management and disposal. Another important aspect of the hazardous waste management rule is prevention of accidents, because it says that all occupiers, I mean, it casts a duty upon all these, for example, industries, a duty to take all adequate steps to prevent accidents and limit their consequences on human beings and environment. And similarly, safety of workers is an important aspect addressed under this. Another major aspect addressed under this rule is transboundary movement, and in the case of transboundary movement, an important part is the Basel Convention on transboundary movement of hazardous waste and its disposal. Here the nodal ministry is Ministry of Environment and Forest, and the key regulatory part is that prohibition of import. I mean this document, this legal instrument prohibits import of hazardous wastes from any country to India for disposal. That means there can't be import of hazardous wastes to India for disposal. Import of hazardous wastes to India is permitted only in exceptional circumstances where the import of hazardous waste is for recycling or recovery or reuse. Similarly, export of hazardous waste to any other country is also prohibited unless this is for reuse or disposal. In both this export and import context, prior informed consent is mandatory. In case there is import or export import or export happens by violating the rules, the consequences is such import. For example, if there is a hazardous waste import to India without getting prior informed consent from the nodal ministry, such imports are liable to be re-exported. Liability is a crucial aspect covered under the hazardous waste management rule, because it says that the occupier, importer, transporter and or operator of a facility is liable for all damages caused to the environment and third party. So this means it says that due to if such damages are caused due to improper handling of hazardous wastes or disposal of hazardous wastes. This seems to indicate that this hazardous waste management rule is fixing liability on the basis of fault. This needs to be contrasted with some of the developments initiated at the under the auspices of the Supreme Court of India, that is the concept of absolute liability, where the Supreme Court in the oleum gas leak case in 1986 supported or introduced this idea of absolute liability, in cases of industrial accidents that involves hazardous wastes. There seems to be a contrast between this absolute liability as introduced by the Supreme Court in the oleum gas leak case and this fault based liability that seems to be the case as prescribed under the municipal, under the hazardous waste management rules. Now briefly let's broadly take a mapping of state level laws, which I already have mentioned, that the PRI, Panchayati Raj institution laws, and the law relating to urban local bodies, that cast responsibility on the local bodies to have a proper mechanism for the management of hazardous wastes. When we look at this issue, there is this duty is not just a statutory duty emanating from law relating to Panchayati Raj institutions or urban local bodies. Instead, this is also a constitutional duty that emanates both from Article 21, the right to life, as well as from directive principles of state policy. There are quite a few interesting cases or pertinent or relevant cases in this context. For example, in the case of Municipal Council Rathilam versus Vardhichand, where the Supreme Court said that it is a statutory duty of the urban local bodies or the local bodies in general, and non-availability of fund cannot be taken as an excuse for non-fulfillment of such duties. Similarly, in BL Vadhera case, the court endorsed this idea or endorsed this this point that there is a constitutional duty upon the government to have proper mechanism for waste management that derives from its duty under Article 27 to take adequate steps for the improvement of public health. And the last point in this module that is a case study of shipbreaking, that is pertinent in the context of hazardous wastes. Shipbreaking in India has been a major source of foreign currency, and another important reason why it was sustained, because it provides significant quantity of steel to the Indian economy, and it also provides direct and indirect employment to huge number of people. This was the major reason why this shipbreaking industry was sustained in India. At the same time, this poses significant threat to human health and environment, and this also needs to be examined in the context of large number of ships being brought into India from outside, and therefore Basel Convention on Control of Transboundary Movement of Hazardous Waste and Disposal is also pertinent in this context, where India is a party to this convention. There has been several controversial issues in the context of shipbreaking. For example, Clemenceau in 2006, where a German ship came to India for disposal, and Blue Lady case in 2006 again. There's recently Exxon Valdez case in 2012. We are not discussing all these cases in separate. Instead, we will try to understand what happened in these cases, and what has been the approach of the Supreme Court in all these cases. To summarize the approach of the Supreme Court, the court's approach has always been overwhelmingly focusing on the economic advantage of shipbreaking industry in India. And to put in a different that means it resulted in undermining the impacts of shipbreaking industries on the public health and the environment. And the court also emphasized on the enormous quantity of steel to be recovered from the shipbreaking industry, and court also emphasized the employment benefits of shipbreaking industries. However, what we can conclude from these cases is that there is a question of weighing or striking a proper balance between the economic and the ecological aspect of shipbreaking industry. In all these cases, whether it was Blue Lady or Exxon Valdez case, the Supreme Court seemed to have given more importance to the economic aspect of shipbreaking industries, and thereafter in all these cases court granted permission to proceed with shipbreaking processes. And this it's pertinent to note that the court recognized or court granted permission despite there was enough reports from non-governmental organizations highlighting the serious adverse implications on health and environment. So to summarize, what we have seen is that in India we have a number of legal instruments that focuses on waste. As far as rules framed under the Environment Protection Act 1986 is concerned, the approach has been to have separate legal instruments addressing issues relating to different kind of wastes, say for example municipal solid waste or electronic waste. The key institutional mechanism is Central Pollution Control Board, State Pollution Control Board and local bodies. And in addition to this, judiciary has played significant roles, whether one should agree with or not. For example, as far as adoption of municipal solid waste management rules are concerned, the Supreme Court has played significant role. But however, in the case of shipbreaking industries, the critique is that the Supreme Court has the judiciary has aligned with or weighed or gave more importance to the economic aspects of shipbreaking industries and undermined the ecological or the environmental aspects and public health aspects of the shipbreaking industries. So to end, the key challenges in this context is we have enough number of rules, enough number of legal instruments, but the implementation apparently continues to be a key challenge. And another major important part is the control of generation of wastes. It is good that we are focusing on collection and transportation and disposal and recycling and reuse of wastes. However, the generation of wastes needs to be also focused, and this might require a significant change in the mode of production and consumption we are following right now, because unless and until we change our mode of production and consumption or production and consumption patterns, and we will continue to generate more and more wastes, and then waste management will continue to be a key challenge. Thank you.